start. So welcome everybody to today's event on the recent decision in the Nicaragua-Colombia ICJ case. This is a program organized by the Latin America Interest Group of the American Society of International Law. And actually around 90% of the programming of the society comes from the interest groups. So for those who are not yet a member of various interest groups, please feel free to sign up to receive more invitations to more events. So with this, we turn to today's event, and I have the pleasure of introducing Maria Camila Rincon, who will be today's moderator. So Maria Camila is an associate at Zuleta Abogados Asociados, where she concentrates her practice in international investment law, public international law, and international arbitration. She has experience in international arbitration, in negotiating investment treaties, in advising international organizations on matters related to public international law, and in designing public policies for the attraction of foreign investment. Before joining the Zuleta Abogados, she worked at Colombia's National Agency of Legal Defense and at the Ministry of Trade, Industry, and Tourism, representing Colombia in its first investor-state arbitrations. She's a lawyer from Universidad del Rosario and has studied investment arbitration at Columbia University in New York and private international law at the Hague Academy of International Law. So with this, I will turn over the microphone to her and she will introduce today's excellent panel. Thank you very much.
Thank you very much, Laura. Good morning to everyone. Thank you very much to all the participants for joining us in this conversation in which we will talk about the recent decision of the International Court of Justice on the alleged violation of sovereign rights in the maritime spaces, sovereign rights and maritime spaces in the Caribbean Sea. This analysis will be made from a legal and geopolitical perspective. And today, three eminent panelists are joining us. First, Andres Hanna, who is an expert lawyer in arbitration and public international law. He is the founding partner of Bofirmir Alvarez Hanna, and he has now moved to a new practice. Andres advises states and investors and acts as an arbitrator in international investment arbitrations. He has been legal advisor to Chile in disputes before the International Court of Justice between Peru and Chile, and also Bolivia and Chile. Carlos Arevalo, Mr. Arevalo is a Colombian professor and researcher of international law. He's currently dean and professor of Universidad de la Sabana Law School, and he has previously worked at the Constitutional Court as auxiliary magistrate. He has acted as expert witness and counsel representing states before the Inter-American Court of Human Rights. He's a former president of the Colombian Academy of International Law and fellow of the Institute for International Law and Justice at New York University. Finally, Laura Hill will be joining us, who's a political scientist and internationalist. She's an expert in human rights and international humanitarian law and is the director of La Línea del Medio. Among the various awards she has received for her work, in 2014, she received the National Award from the Cycle of Journalists of Bogota for the series of columns she published on the International Court of Justice ruling in 2012 that resolved the dispute between Nicaragua and Colombia. Well, before getting into the analysis of the court decision, we will review some of the history and context of the disputes between Nicaragua and Colombia before the court. The first dispute between both countries began more than 20 years ago. In 2001, Nicaragua presented a claim against Colombia before the court, requesting it to declare, among others, to delimit the maritime border between both countries, and that the San Andres archipelago is an enclave. On 2012, the court issued a ruling resolving the dispute, and it rejected Colombia's position that the maritime line dividing both countries was the 82nd meridian. 9 days after the court's ruling, that is on November 28, 2012, Colombia denounced the Pact of Bogota, the treaty through which the court acquired jurisdiction over the dispute between the parties. Finally, on September 16, 2013, Nicaragua filed a second claim against Colombia, asking the court to delimit the continental shelf beyond 200 nautical miles. Now, the claim that brings us today to this conversation was filed by Nicaragua on November 26, 2013, in which Nicaragua claimed, and well, it presented a claim against Colombia for the alleged violation of its sovereign rights and maritime zones as declared by the court in its 2012 ruling, alleging that Colombia violated the delimitation fixed by the court. Now, we will move to the present decision of the court. And Carlos, I would like to ask you, what were the main points in dispute between the parties, and what did the court decide about these points?
Camila, thank you very much to you, to Laura, to James, to everybody for organizing this panel. Now, regarding your question, and I know that we have a time issue here, so I'm trying to be very brief. In the history, you have to take into account that after the 2016 admissibility decision of the court, in 2017, Colombia submitted counterclaims, submitted 4 counterclaims, 2 of them who were accepted. So that's going to be on the background of the case. Now, from those 4 counterclaims, 2 of those 4 counterclaims were not accepted, and they were counterclaims related to environmental issues. I mean, the fact that there has to be a protection to the environment in the area of the Southwest Caribbean, and the fact that that protection also entails the protection of the inhabitants of the San Andres Archipelago Islands and Keys residents, the Raizales. Now, the 2 that were accepted were related to the historical fishing rights of the Raizales community, and the fact that Nicaragua was violating international law by establishing a straight line on its baselines, which was something that was not clear in the 2012 decision. Having that as a background, we come to the allegations of violations presented by Nicaragua of the 2012 maritime rights recognized to the Central American state. And in that, the main reasons for alleging those violations were centered in 2 main parts, or were addressed in 2 main parts by the court. First, it is regarded as violations by Colombia to the rights, to the maritime rights of Nicaragua. And in that part, mainly, it was done by some incidents of the authorities of Colombia in the Southwest Caribbean Sea. Also, some alleged authorizations given by the Directorate, the Maritime Directorate of Colombia, the MAR, and by the governor of San Andres to allow, rights given by Colombia to allow fishing in this area. And finally, the fact that Colombia authorized oil exploitations or give license to oil exploitations back in 2010, and that could affect the rights of Nicaragua. This is the first part related to the contested activities of Colombia against Nicaragua. Now, the second part is a very interesting part that is related to the fact that Colombia has created, by Decree 1946 of 2013 and then amended by Decree 1119 of 2014, an integral contiguous zone around the archipelago of San Andres. And how that integral contiguous zone might violate the maritime rights of Nicaragua. So those are the two main issues. Now, what did the court say regarding these 2 issues and regarding the counterclaims? Regarding the first issues, Nicaragua asserted around 50 incidents in the Southwest Caribbean Sea, and it was a strong evidence discussion to the court. And the court determined that many of the evidence presented by Nicaragua, it's going to say the same later to some of the evidence presented by Colombia, but some of the evidence presented by Nicaragua were not enough to assert that the incidents demonstrate a violation of Colombia to international law. Only around 10 incidents demonstrate to have a standard of proof merit for the court to analyze if it was really a violation of international law or not. And after analyzing it, the court established that indeed Colombia violated international law. Now, Colombia justified the incidents by saying that it was protecting the environment and that was enforcing international conventions such as the Cartagena Convention from the protection of the environment due to predatory fishing exercises committed by nationals of Nicaragua or people authorized by Nicaragua to perform those predatory fisheries activities. But the court considered that that was beyond the international customary law regarding what exclusive economic zone rights of a state conveys, and in that sense that it was a violation of international customary law by Colombia. Regarding the, yes, Maria Camila.
Sorry, what was the standard of proof applied by the court? How did the court analyze the evidence presented by Nicaragua and, well, then in your analysis by Colombia?
It was very interesting because the court said that, for example, many of the evidence supported by Nicaragua, I mean, it was based on affidavits precisely created for the purpose of the discussion of the case, and that it was not really an objective. It could not be seen as an objective element of evidence. Actually, the incidents that the court considered that were proper to analyze under a standard of proof were because they were not only alleged by Nicaragua, but also recognized by Colombia in accordance with the maritime authorities of Colombia and the naval forces that demonstrate that indeed Almirante Padilla frigate and other frigates were in the area where Nicaragua is alleging the incident. It also analyzed some communications by the fishermen, and but it considered that it didn't fulfill the threshold of a standard of proof that, according to the court, was meant to establish the violations. Now, for most of the incidents, now regarding 10 incidents, it was recognized and accepted that it was. Now, regarding the activities in the authorizations given by the second part of the claims of Nicaragua regarding the violations committed by Colombia that were alleged authorization of fishing activities and maritime scientific research, it was established by the court that indeed both the governor of San Andres and the DIMAR gave those licensing for fishing, and that those licensing concluded in many cases in the fact that those companies or people develop fishing activities in the economic zone of Nicaragua, being that a violation to international law. And finally, regarding the alleged exploration oil licensing, the court established that there was no evidence to demonstrate that the blocks authorized in 2010 were going to be exploited by Colombia, according to the declarations of Colombia, and that indeed that do not constitute a violation of international law, because those oil exploration licensing given by Colombia were never going to be executed, were not executed, and was not, according to Colombian authorities, going to be executed. That's the part of the violations. Now, here is also very important. I know we're running out of time, so I'm going to be very brief on this. The remedies. There was, in the initial part of the case, by the filing of Nicaragua alleged that a compensation was due because of how Colombia, with its action, affected the rights. But it was in the procedure demonstrated that actually it was not demonstrated by Nicaragua that there were some negative effects that amount to a compensation. So no compensation was due. Not request for compensation was declared against Colombia, and it was considered by the court regarding other measures of remedies requested by Nicaragua that the decision itself and the content of the decision was enough. The second part of the violation is very interesting, and we can go deep on it if you want later on, because I don't want to use more time, and I want my co-panel members to probably explore in deep, and it's the fact of an integral contiguous zone. And it's the fact that the court is saying that Colombia may have an integral contiguous zone, that concept is not per se a violation of international law, that may overlap with the exclusive economic zones that it considers of Nicaragua, as it considers that there are parallel rights, or rights that go in parallel, but nonetheless, that the integral contiguous zone established by Colombia according to the government decrees are violating the two essential elements that under Article 33 of UNCLOS are considered to be customary international law, which is the 25 miles length and the fact that there are some functions that might not be exercised by Colombia under that exclusive economic, under that contiguous zone, which is, for example, security. There was a big discussion in the court, and the court did a length, not a length, but a good analysis on how in history Article 33 and the elements of Article 33 and since 1958, how it was developed, the idea of contiguous zone. It didn't precisely contain the element of security, so it was something that Colombia could not allege. So at the end, contiguous zone might exist, but it has to be under the elements of customary international law regarding length and material functions developed by the states.
Thank you, Carlos. I was just going to ask you a last question on this point, and is what was the evidence or the position presented both by Colombia and by Nicaragua regarding the customary international law, like the demonstration of customary international law about other functions of the contiguous zone, for example, security and other functions? What was the evidence or the allegations presented by the parties?
So the thing is here regarding that point, Maria Camila, and it's a very important question, is that Colombia alleged that Article 33, it's an initial customary international law, but it has evolved according to the practice of states. So, it alleged that elements, for example, security has evolved, and that today many states in its national legislations include security, not only fiscal or sanitary or immigration issues, but also security, an issue that is recognized by the state practice. Now, the court contradicts that position of Colombia, going back to the history of the concept of contiguous zone, going to the 1958 convention, but also going to different diplomatic conferences, in which it was discussed. It was precisely discussed, the idea of including, I think it was Poland, who in one of the diplomatic conference presented a proposal for including security inside what now we know as Article 32 of UNCLOS, and it was disregarded by the states. So those were some of the evidence. And although the court recognizes that some states include security inside its national legislations, though that position by those states has been contradicted under international law. So that's the reason why security was not included. Nonetheless, and here's where you can see a little bit of contradiction by the court, because it does recognize that, for example, historical site, archaeological and historical sites inside the contiguous zone might be protected, and that is also not mentioned in Article 33. So that's an evolution of the customary international law that it is recognized by the court, and it was recognized by the court in the decisions. So on one hand, the court is saying, no, it's only Article 33, but on the other hand, the court is also saying, well, it's Article 33, but for example, regarding archaeological sites, it might be extended according to the practice of the states, and there is enough evidence of the practice of the states. Now, that's not necessarily wrong under international law, because according to the court, you can understand that there is far more evidence of state practice regarding archaeological sites included in the contiguous zone. That's security, and also the fact that security has expressed discussion by the states, and it was expressly denied by the state the fact that security might be included. Now, nonetheless, the problem that still arises here is how are you going to comply with the requirements of Article 33 under UNCLOS regarding contiguous zone, but at the same time comply with other obligations that you have under international law, for example, very relevant for the area, for the region, and especially for Colombia, which is drug trafficking and the fight against drug trafficking. Now, that matter was not deeply addressed for the court, and there's certainly uncertainty on how are we going to comply with those obligations under the ruling of 2022.
Thank you, Carlos. Well, now we will move to Andres' questions. He has to leave us a little bit earlier, so I think we should, Andres, if you're fine with it, we can make two questions to you now. So first, Andres, in your experience in litigations before the court, how do the parties and the court approach such a fact-intensive case?
Thank you very much, Camila, and thank you for the invitation to the organizers. Well, first of all, as you said, I apologize. I will have to leave early, so after answering your questions, I'll have to leave you. I'm really sorry for that. In principle, you may say, no, that an ICJ case is no different than any other case, in the sense that the parties, they have the burden of proof, they have to prove their case, and the court has to consider the evidence presented by the parties. Is something that we all are very accustomed when we deal with international disputes. But the court has had some difficulties, in my view, dealing with evidence, with evidentiary issues, with means of evidence, with how to challenge that evidence, and the probative value, the opportunity to produce evidence. So really in ICJ, it's not like in any other international case that many of us could have been involved and how evidence is presented. But in this case, as you said, evidence was critical because there were allegations that Colombia violated its international responsibility. There were also, and therefore really the facts mattered, because you really will have to prove that Colombia violated, and the party presented a lot of facts. And I think that when you look at how the court dealt and the parties dealt with that, you can make a few comments, if I may. I think that my first comment, which is an overall comment, and that is, you see somehow I would say that the difficulties of dealing with evidence in international Court of Justice cases, when you see how the parties presented evidence with respect to the allegation and how the court dealt with it. A good example that I can come back later is the example of the 11 affidavits, where really are witness statements by the Raizales, that they were presented as affidavits, and I will come back. They were not contested. There were no oral appearance in front of the court. There were no cross-examination, anything. They were just the affidavits, and not surprisingly, the court didn't give much weight to that 11 affidavits. Actually, my own experience in the cases dealing with the court, that the issues of evidence are always difficult to determine how you will really produce the evidence that will satisfy the court. Let me give you two examples. The first example is in the case with Peru. There was an issue of how really, what was how the parties understood the maritime, if there was a treaty, and how the parties understood that there was a treaty. The court understood there was a tacit treaty, but then to determine what was the content of the treaty, the court really came out with an evidence that was not produced by any of the parties. The court produced its own evidence. There was an issue that was not alleged by any of the parties, and decided the case based on that, and created a line that was, a line that none of the parties really alleged. That was completely surprising. And I think Judge Donahue, the president now, actually made in its concurrent opinion, made a comment about the issue that the court should do better with issues of due process and evidence, because as I said, the court created its own evidence, produced its own evidence, and decided the case based on it. The party has no chance to comment on that evidence. Something that an international case, another international case, international arbitration, could be granted for annulment, for example, And the second is the recent case that was a very technical case, and the case was about a river. The last case, we believe, is how the river cases, people may know, are very technical cases. You really need to present experts, because otherwise it would be difficult that the court will understand the issues. Each party presented their expert, highly regarded in our case. Experts are global experts on rivers. And the court has a lot of difficulties in order to decide how the expert will be presented in front of them orally, how the examination on chief will be doing, how the cross-examination will be doing. And at the end, we have to go back and forth with them, and we ended up with something that was more or less reasonable in terms of, how to really challenge and the evidence of the other experts. Still, the decision is pending. We will see how they deal in the decision about that. So having said that as a background, I can say that it was interesting in this case that the court, first of all, they really did in one paragraph, right? It's paragraph 64. The court said, this is how we will deal with the evidence. And they said, first of all, burden of proof, which is something quite obvious, right? Burden of proof is on the party that alleged the fact and it has to prove the fact. In this case was Nicaragua. They have the burden of proof for the international responsibility. Colombia has the burden of proof for this long-standing artisanal fishing rights of the raizales. And then it said, it make some points using its past jurisprudence about how to deal with the evidence, which if you look at it, is quite obvious, right? There is nothing very surprising there. They said that the court will be cautious with the materials prepared for the purpose of the case. But there is a lot of things that you prepare for the purpose of the case. Witness statements, for example, expert reports are all then prepared for the purpose of the case, like the affidavits. There's no other way of doing it, right? So you see that these difficulties of the court in dealing with how the issue has to be proved and what are the means of evidence that you may use. And the court, using that criteria, then gave a little weight to some of the evidence presented by both of the parties. The court then speak about the secondary sources, and which is also obvious. They said that the contemporaneous and direct sources will be more probative value and will be credible. And then they said that in particular, they will give evidence to statements made by representatives, they said, acknowledging the fact that they are adverse to them, which is, again, something obvious. You don't need to, there is no rule of evidence there. It's just common sense on how you will present the evidence. But having said that, I think still is useful because the court gave some guidance using its past jurisprudence on what is the evidence, what is the weight that will give to the evidence, and then apply those criteria to the evidence presented by the parties. So what can be taken from all that in order to finish the first question? And again, I think the raizales is also a good example. Yeah, I think that the court is moving ahead in terms of dealing in more detail or in a more careful way with evidence. And I think the taking for the parties will be that if you are in front of the International Court of Justice, you will have to think very carefully if your case is based on facts, like this case were, some of the cases were, how you really present evidence that comply with this guidance given that the court, but also how you can use other means of evidence in order for the court to be satisfied. I hope that it will not be too far in which the court will start accepting witness evidence or some witness evidence, qualified witness evidence that in this case in particular could have been, in the case of the raizales, useful. No?
Thank you very much, Andres. And just one last question before you leave is, what approach could Colombia and Nicaragua take to comply with the court's decision? Is just a very brief question.
Yeah, it's a very interesting question, Camila, considering what was the court decision. And I can make 3 comments with respect to that, very brief. The first is that the court was careful in not getting involved in the compliance of the court decision on how the 2012 and this 2022 decision will be complied by the parties. Actually, the court rejected the remedy requested by Colombia, by Nicaragua. Nicaragua said that the court want the court to be involved until Colombia complies fully with the 2012 decision, and the court says we will not be seized to participate in that. Is for the parties. Really, the implicit message is for the parties to comply and to understand and to decide how they will comply with the decision. Is up to them. The second issue that I think is important, is a good message for Colombia, is the lack of endorsement, in my view. There is no endorsement, in my view. I've seen some comments in Colombia that said otherwise, that Colombia's position that a treaty is needed to establish the border, and therefore they cannot comply with the court decision 2012, and then there is a treaty that would establish the maritime border. I think the court was clear and not giving in understand that the 2012 decision is in force and is applying, and that the court and that Colombia has to be abide with it and consider that we're a violation of that decision by Colombia without, of course, this domestic law implementation, which I think it's a good message to understand. And the third comment has to do with the decision of the court regarding the raizales. You know, and has been some discussion about what the court did, because the court said that, right, that it seems that the best way of dealing with this issue is to negotiate a bilateral agreement for the raizales access to the fisheries. And you see that the court is not an order of the court, right? The court didn't order the parties. It's not an obligation to negotiate, and we know a lot about it because we were involved in a case that was only about an obligation to negotiate. But the court somehow gave guidance as to what is the best approach to solve the issue. Actually, the court notes, right? So I don't think that you can say that the court established an obligation to negotiate, but I think it falls short of doing that, because the court said that it understood that the declarations by Nicaragua, by Ortega, and statements made that the best way forward is to establish a bilateral treaty and negotiate the access to the fishery. So even though it's not a negotiation, it's not an obligation to negotiate, the court established a clear path. I don't have to remember to the people that is in this call that there is general obligations of negotiation of the state to solve peacefully their disputes in the United Nations Charter Treaty, in the United Nations Charter, in the OEAs, and also in the Pact of Bogota, even though Colombia is no longer a part of it. So I think that the interesting thing, in my view, is that the only way to resolve the pending issues, that are a few of them, as Carlos was saying, in the 2012 and 22 decision, including this, you know, the inclusive, the contiguous zone, as well the straight baseline that were rejected by the court. There are a few issues, including these raizales fisheries, right? We need that the parties will engage in negotiations. And therefore, I think that the court is sending a message, in my view, in particular to Colombia, that the best way of dealing with the problem is to have a direct and bilateral negotiation with Nicaragua in order to comply with the decision, establish the right, and define the rights of the parties. And it seems that it would be the only way to really comply with things that at this point, and I think this is interesting, is not only in the interest of Nicaragua, is also in the interest of Colombia. Because in order for us to establish, for example, a fisheries right for the raizales, the court said you will need to get a bilateral agreement with Nicaragua. So it's for Colombia. Colombia also now has incentives to move ahead and talk to Nicaragua to somehow determine and establish the number of issues that, again, they are not in the interest of Nicaragua, but also a number of them are in direct interest of Colombia, which could more easily justify in front of public opinion the need to sit with Nicaragua and directly resolve these issues.
Thank you very much, Andres, for your time. Thank you.
No.
Laura, what is the relation between this decision of 2022 and the 2012 decision?
Hi, are you listening to me? Because I'm having
not very well.
Okay, well, let's try it. Okay, first of all, I'd like to begin with a disclaimer. I'm part today of the foreign policy transitional team of President-elect Petro. So before I begin, I would like to say that I'm talking here as, you know, in one of my final roles as an analyst before. I'd like to tell you the story of politicians and lawyers to begin with, in order to understand the relationship between these two rulings. As with many of the cases before the International Court of Justice, there is a political story behind all this. And the political story shows the failings of Colombian politicians and legal teams for decades, for a failure that lasted decades to understand Nicaragua, to understand what Nicaragua wanted and how Nicaragua was going about it. So immediately after the ruling was issued in 2012, basically the Colombian government got stuck between a rock and a hard place. And the reason why I'm saying, this was a very difficult moment for the government is that we were in the middle, we were beginning negotiations with the FARC, peace negotiations with the FARC that were widely opposed. So by the opposition here, by the right-wing opposition here. So the government felt that they couldn't have two war fronts at the same time, the peace process and the Nicaraguan case. So basically, the president actually invented a formula that had no legal content. He basically said, we will comply, but we are not applying the sentence, the ruling. That's basically the translation of what he insisted on. We will comply, we will not apply. That distinction basically tried to send a message that eventually there will be compliance with the ruling, but not for now. And that was particularly preoccupying, as you could probably suspect, for Nicaraguans. Presidents often delay, states often delay compliance with international rulings, but very seldom you have the head of a state say, we're not complying right away. When President Santos said this, the legal team had to put content on this. So how do we make out of this political statement? How do we fill it in with legal content? And basically, they had 4 major challenges, in my view. The first one is that no one in Colombia had actually made sure that Colombians understood the 2007 ruling, when basically the meridian 82nd fell as a limit, was actually dismissed as a maritime limit. That was clear in 2007. Not only was it clear in 2007 in the ruling, every single president in Colombia from the 60s until 2007 had been told that Meridian 82 had no legal standing as a limit, that this was a Colombian fiction. And it was a Colombian fiction for things that we already discussed in other webinars. But everyone here in Colombia in 2012 was convinced that the Meridian 82nd was still a limit. So that was a major political problem from the government. The second one, it was a broken map. We had a broken map, we had enclaves, and that was politically unacceptable for the president. And the third one was the question of changing limits because an international tribunal said so. So basically what they did is what Carlos Arevalo just described. How do we reunify waters? It doesn't matter whether the integral contiguous zone is actually territory or not. Basically, what it allowed was to reunify the map. Colombia was able to present a map where the enclaves disappear. All those questions, about whether, what are the faculties, the powers in an integral contiguous zone, that doesn't matter to the Colombians. That matters to the lawyers. It doesn't matter to Colombians. Colombians were able to see a new map where the whole all the islands and the keys were reunified. And that was what politically mattered. And then in Colombia, there was no tradition, there was no precedent, there was nothing that said that we needed a treaty in order to change limits. Basically, what Santos did for political reasons, and I think it was a major mistake because it will make life impossible for every single president from now on, was to go to the Constitutional Court and basically say, Constitutional Court, please tell me, I got this ruling. Don't you think that we will need a treaty in order to comply with this ruling? Well, a treaty needs ratification in Congress. Well, which Congress in Colombia will ratify a treaty in the terms of the ruling, at least at the time, when Santos was president? That was a political impossibility. And I'm speaking in that tone because that was pretty much what Santos asked the court. Basically, it was a supplication. Please tell me I cannot, change the limits right now. Please tell me I need the treaty. And the court basically said, yes, you do need the treaty in order to change limits. So where we are right now is that we already had 2 rulings against Colombia. The second one was absolutely unnecessary, politically and legally. Had someone been able to read Nicaraguans, they would have known that Nicaragua was going to present a new case against Colombia for non-compliance. That was clear. But believe me, I've been following this case for 10 years. Step by step. Carlos here knows how close I've been following this. Colombians in the government believed that Nicaraguans wouldn't dare argue non-compliance, that they will not dare do so. And it was clear they did. And it was clear not only that they did, but they also went for the extended continental platform. So here, in my view, what we have is a failure of politicians, not of lawyers. In Colombia, the argument is we don't have a good legal defense. Nicaragua is a political dwarf, but a legal giant. We have never been able to find a good legal defense. I don't share that view. I think Colombia had the best defenses we could have, but sometimes law is not in your side. And this is what's happening in this case. That's for me, Maria Camila, for now.
Thank you very much, Laura. We're going a little bit back and forth. Carlos, how did the court analyze the issue regarding the ancestral fishing rights of the Raizales? This is one of the most interesting points of the decision, in my view. I would like to know your views on this point.
It is indeed a very important point. As I mentioned in my intervention before, at the beginning of the panel, you have to take into account that it was a counterclaim. And there was a huge discussion among the judges of the court regarding if the counterclaim was valid or not, especially because, as we said, Colombia presented 4 counterclaims. 3 of them somehow related to the issue of Raizales. One, the straight lines, which is a different issue, also addressed by the court. But the first 3 counterclaims 1, 2, 3, were related somehow to Raizales communities. The first 2 related to environmental issues, and the third to the fisheries rights. And the first 2 claims were disregarded by the court because they lack, according to Article 80 of the rules of the court, they lack direct relation with the principal claims presented by Nicaragua. And that, I mean, you can see the environmental affairs, the environmental discussions all over the case, not only in the analysis given by the court in the order of 2017, but also in the 2022 decision, where it analyzes the decree of the 1946 decree of 2013 and the integral contiguous zone, and the justifications given by Colombia to the incidents with the Nicaragua fishers. They are all related to environmental issues, and that was somehow disregarded to the court. So the way in which environmental issues may affect the raizales is a big issue, it's a big pending issue that was not addressed directly by the court. And this is something that it has been addressed before by the court, and it's very, I mean, the facts, the way how a decision of the court may have an impact in individuals, not only in the state, has been addressed by the court. As was highlighted by late Judge Cansado Trindade in its opinion regarding the order of 2017, 3 Latin American cases. The Costa Rica-Nicaragua case of 2019, Paul's Mills case, Argentina and Uruguay against Uruguay, and the Peru against Chile case. 3 cases in which the court went beyond analyzing only effects of a decision to states, but goes into how that decision may affect people and may affect the right of people and may affect, in this particular case, the right of the raizales. So the court leaves us without the element of discussion of environmental and how predatory fishing, for example, may affect environmental rights of the raizales, but it focuses only on the ancestral, historical fishing rights of the raizales. And the argument of Colombia was mainly based on 2 elements. On one side, on declarations given by members of the raizales community and inhabitants of the archipelago of San Andres, the 15 affidavits that Andres mentioned in its intervention. And the second element was the declarations made by President Ortega after the 2012 decision. Now, regarding the first element, the court, in another analysis of a standard of proof, as was highlighted with Andres, the court decided to go on flexibility. I mean, it recognized how difficult, because it did it before in Costa Rica v. Nicaragua case of 2019, how difficult to establish historical fishing rights is to establish under, I mean, it's too evident. It's how difficult it is to procure evidence to demonstrate those rights. And because of that, it decided to do a flexible analysis of the 11 affidavits presented by Colombia. Nonetheless, the court concluded that there was these 15 affidavits were not evidence enough that there was historical fishery rights in the exclusive, not today, after 2012, is considered to be exclusive economic zone of Nicaragua, and or that by the decision of 2012, the rights of the raizales were affected. Pretty much the analysis given by the court is an analysis saying, look, it seems like the raizales and their fishing rights, I mean, they are done in proximities to the archipelago and not so far as Colombia is trying to demonstrate with these affidavits. And the important point here is that it uses declarations given by Colombia before the International Labor Organization, recognizing this fact, recognizing that the rights of the raizales are not going to be, the fisheries rights of the raizales were not going to be affected by the 2012 decision. So there's a contradiction inside the government of Colombia that was, of course, used by Nicaragua, but was taken into account by the court. Now, regarding the second element, the element of the declarations given by the president of Nicaragua, President Ortega, the court says that it is not, I mean, its declaration could not be considered as a unilateral declaration that amounts to a recognition of those rights of the raizales community inside the territory, or the now territory under the jurisdiction, the special jurisdiction of Nicaragua. My opinion regarding the decision, I mean, at the end, the court says and highlights that the point that Colombia should take advantage of the willingness, in the best possible way, of the willingness of the government of Nicaragua to respect the rights of the raizales, to celebrate a treaty that recognized those rights of raizales. If, I mean, it is established in the negotiations between the two countries that those rights need to be protected in the, especially fishery rights in the exclusive economic zone. Now, what I most missed from the case is that environmental rights analysis. I think that's. I mean, it was. If the two counterclaims were related, the 3 and 4 counterclaims were related, it's not very clear the argument of how these first and second were not. I don't completely agree with the court on that, although I know the discussion is very open. And I think if gives, and I'm going to give Laura, who I know it's the expert on this issue, to do the probably better analysis than I do, for the political like flag that the court is raising on behalf of Colombia, and it's giving with its decision a possibility for a future, I mean, probably the next government of Colombia to enter a negotiation that will finally put an end to the fact that Laura very well highlighted, that this we're going to comply, but it's inapplicable, that doesn't have any legal ground and has terrible political consequences, as Laura highlighted. Probably putting an end in time, something that politically can be understood and can be better explained to action. Are you guys hearing me well? I probably lost connection at the end. I don't know if you.
Yeah, we lost you. The
So
last.
I was just very briefly, I was saying, and probably Laura can go deep on this, saying that this gives an element, the decision gives an element that politically the government, next government of Colombia can take into account. And it's, look, we're going to finally put an end to this discussion that this is, we're going to comply, but it's inapplicable. That doesn't make much sense politically or legally. And it complies with the 2012 decision, but also recognize fisheries rights to the raizales beyond the border established in the 2012 decisions, which might be something that it's going to be easy to sell and probably agree, doing the willingness that the court recognizes Nicaragua is showing between the two countries. That would be my position.
Thank you very much, Carlos. And this leads me to the next and final question to Laura, precisely on that point. And it is that, I don't know if you feel comfortable about talking about this, but well, as obviously you know, but our audience may not know that Colombia has recently elected a new president, and is also a shift on the political paradigm in which we have been like the last couple of years. So do you think, Laura, that this shift in the states, do you think that this would imply a shift in the state's policy regarding this case?
Yes. The president-elect has already said he will seek the treaty. The problem is how to seek the treaty. I mean, how to make it acceptable enough in order to be ratified and digested by public opinion. So a treaty that simply brings in the 2012 ruling as such as Nicaragua expects. Nicaragua, what does Nicaragua want? Nicaragua wants basically a treaty that will just include the limits of the 2012 ruling. That's a political impossibility in Colombia. They are willing, because they already said so, they already said so, as Carlos emphasized, they're willing to include some prerogatives for the raizales. but not as fishing rights. And on the question of fishing rights, I want to make a comment, and I want to make a comment because I think it is important in terms to understand the discussions that are taking place in Colombia. In Colombia, as I said before, there's a lot of discussion. Oh, if we had had this defense, we would, the 2012 ruling would have been different. It would have been more beneficial for Colombia. And there's a lot of discussion. If we had brought in the question of the fishing rights in 2012, we would have been able to get a better ruling. I just hate to disappoint Colombians who are in this panel, but that's not the case. And that's not the case simply because the fishing rights did not exist. And if you read, the 1,500 pages of the latest ruling, one of the questions you ask yourself is why Colombians' claims on fishing rights is so weak. Why is it so weak? If we spent 10 years saying, if we had claimed that before, we would have had a better ruling. And the reason is weak. The reason the argument is weak because we didn't have the evidence. The testimonies Carlos was referring to are very weak indeed. They do not talk about fishing rights in the areas where Colombia was claiming fishing rights existed, which were so far away from the coast, so far away that the only fishing possible basically was industrial fishing. On top of that, you had what Carlos mentioned, the fact that when these fishermen actually went to the ILO, Colombia actually claimed they did not have the rights, and that was something Nicaragua was able to exploit. But I was able to look at the research the Colombian team had on fishing rights. And the reason why they didn't present it to the court, it was that basically it was against Colombia. So that we can, if we get a treaty that basically gives whatever benefit as rights or as in any other type of package to that population, that's already a win for Colombia. But I think the way to make the conversation useful, not only for Colombia, for Nicaragua, but also for the region, is to talk about an environmental regional regime we can agree on. If we move the conversation, we say, of course, we will respect the limits placed by the court, but let's talk about an environmental regime, and we can shift the conversation to something larger. I think that will give us the way, it will give us a way to make this treaty happen.
Well, that's a very interesting approach, Laura. Thank you very much, all. I think we just reached our time for this event, but thank you very much to all the participants and of course to the great panelists we had today. I think that I cannot thank on better panelists to address this issue. So thank you very much for your participation, and thank you very much, Azel, for opening this space